Hi, good morning, class. So, in the last class, we discussed about the corporate agreements and we drafted limited liability partnership agreement. So, now today, I'll be starting with a new topic, which is banking agreement. And in the banking agreement, I'll take up the loan agreement in this first class. Before proceeding with the banking agreements and the loan agreement, I want to just clarify that we have already discussed the limited liability partnership agreement and the partnership agreement, which we decided to discuss today, is more or less similar to the limited liability agreement. So I'll be discussing only the clauses which are slightly different from the limited liability agreement. Rest everything remains the same. Let me just share my screen. Before proceeding further, anyone has any doubt till now? Just let me know if you have any doubt, because in the evening class I'll be taking up the doubts and I'll be completing the loan agreement and the other banking agreement. So please let me know if you have any doubt. Is my screen visible?
Yes, ma'am.
Okay. So this is partnership agreement. Similar to an LLP and other agreements, this too has an introductory clause. Then it has a recital clause. Okay. Then besides the recital clause, there is a partnership name and a purpose, of course, similar to a LLP clause, that this so and so are the partners and so partners agree to open a partnership firm under the name so and so, which will be governed by so and so laws. This partnership agreement has been formed under the terms and conditions as set forth herein, and a purpose. Purpose over here is important. This is the purpose, that here in this case we are incorporating this partnership firm to develop, sell, maintain and other tasks related to residential and commercial apartments. So basically this is to start our real estate business. We are organizing or incorporating this partnership agreement which will be having three partners which are defined above. Okay, partner A, B and C. Now, duties of partner over here also similar to an LLP. Every partner has a proper set of responsibilities. Suppose partner A will look after the paper book and all the financial things. Partner B will look after the books of account, profit loss, and so and so. And partner 3 will look after the other site work. Okay, but all this will be done in consonance and in transparency with the other partners. So though here partners are having their own set of duties, but everything they are doing has to be transparent, has to be disclosed and has to be in consensus with the other partners. Okay. Now, one other thing which is very important over here is, if you remember in the LLP agreement, I discussed that suppose partner A, partner B, and partner C have contributed 20%, 30%, and 70% in this ratio to the particular firm. Okay, so they would be liable or they would be entitled to similar profit or loss ratio. Suppose the company incurs a loss of so and so rupees. So then partner 1 who has contributed 20% will be liable only for 20% of the loss. Partner 2 who has contributed 30% will be liable to the 30% of the loss. And partner 3 who has contributed 70% will be liable for the 70% of the loss which the company has faced. Similarly with the profit. Now here what's the difference is, suppose, let me just give me a second. Now here, suppose partner A has contributed 20%. Okay. Partner B has contributed 30%. and partner C has contributed 70%, which is similar to what we discussed in the LLP agreement. So if this was an LLP agreement, then A, B, and C would have been entitled to 20, 30, and 70% of the profit. Okay. So this was something which is fixed in LLP agreement. But if we are entering into the partnership agreement, then in that case, if mutually agreed between A, B, C, then we can have this particular proportion or ratio of profit loss also. Otherwise, if there is no such explicit provision in the partnership agreement, then in that case, what will happen in a particular partnership agreement? Suppose a company incurs a loss of crores. Okay. Then in that case, A will be liable for 3 crores. B will also be liable for 3 crores. And C will also be liable for 3 crores. So if you can see, if in case we do not have any explicit clause of how the ratio of profit and loss will be distributed among the partners, then in that case, in a partnership agreement, by default setting, all the 3 partners will equally share the profit loss ratio. Getting my point? Yes, class? Are you all getting my point that what is the difference between an LLP and a partnership agreement? Okay. Complete silence. No, yes, no, no.
Yes, ma'am.
Okay. Give me a second. Okay. Then coming on to the right and liabilities. Now over here, what I have done, I have included an explicit clause which says partner 1 will be entitled or liable for 25% of the profit loss. Partner 2 will be liable or entitled for 40%, and partner 3 will be liable or entitled for 35%. So this is very subjective. If you are having a mutual consensus that saying that okay, this will be the proportion of profit loss, it can be either depending on the role, it can be either depending on the contribution made by each partner or on the position of each partner. If not, if there is no such clause in the partnership agreement, then by default this pattern will follow. Then after that, one more clause which is different from the LLP over here is the secession. Secession over there, if you remember in the LLP, I have told you that if one of the partners either dies or is declared insolvent or any other thing, then that insolvency of one partner or the death of one partner or the expulsion of one partner would not affect the dissolution, would not affect on the dissolution of the entire company. Okay, in so and so case, other partner will come into the picture if the remaining partners agrees. Okay, but now what happens over here is, if in case there is a death of either of the partner, or in case one of the partner is expelled or one of the partner is declared insolvent, the whole of the partnership firm may be dissolved. Okay, let's go on to the clause. This partnership shall be valid for the term of 10 years, and after the expiry of this term, the partnership shall cease to exist subject to the renewal. So now here the term of this partnership, which we are entering into, is 10 years subject to renewal. Apart from the expiry of the term of this agreement, as mentioned in the so and so clause, this agreement may cease to exist. Now here the word is may. We can have the contemporary or a different clause depending upon what the partners under this deed actually agrees to do so. But if in case nothing they have agreed to do so explicitly, then this pattern will follow. If in case the death of any partner occurs during the term of the partnership may cease to exist if other two partners mutually agree to do so. Okay. If there is death of any one partner, then the partnership deed may cease to exist immediately. The partner shall first give preference to the successors of the deceased to take over the shares and other liability of the deceased. If not agreed, then the partners shall mutually agree to take up the shares of the deceased equally along with the other liabilities. If not, then offer a third party to buy the shares. So now this particular three clauses which I have included talks about a scenario where they have agreed to enter into some sort of settlement or agreement where they want to sell off these shares which were of the particular partner who has now died to either his successor or to any third party or to mutually share between the other remaining partners. Okay, if not, then the partnership may cease to exist. If any of the partner is declared insolvent or is undergoing insolvency proceedings, if any of the partner retires, or if any of the partner is expelled for the reason of commission of wrongful, fraudulent, or illegal activity. Then comes the indemnity. Indemnity is similar to what we have discussed in the LLP. So this particular agreement is more or less similar to what we have discussed in the LLP agreement. The only difference over here is the distribution of the profit loss ratio, and the other is the cessation clause. Okay. Any doubt in this? If not, I'll move on to the banking agreement. Okay. Now tell me what all will come under a banking agreement. What according to you will be, what all agreements will be covered under the banking agreements?
Loan, mortgage, pledge, indemnity, pledge, and all these agreements.
Right. Right, it does. So today we'll be taking in the first class loan agreement, which is a very basic single bank loan agreement. So what do you understand by a loan agreement? What do you understand by the term loan? What?
Borrow money from the lender.
Sorry?
Borrow money from the lender.
Okay, borrowing money from the lender. Anyone else? Okay, I am moving further. So a loan agreement, what is loan agreement and why it is used? A loan agreement is a contract between a lender and a borrower under which a lender makes available loan monies to the borrower. In essence, the loan agreement provides the contractual basis under which the loan is made. The borrower agrees to pay loan sum and abide by the terms of the loan agreement in exchange for the loan. The loan agreement sets out the terms of the loan arrangement, including the amount of loan, security provided as collateral, any conditions to be satisfied prior to drawing of loan, interest payment provisions, undertakings of the borrowers, and warranties and representations. The agreement also sets out applicable security with provisions relating to term and termination of the agreement upon the occurrence of certain default events. So basically, a loan agreement is a contract wherein a lender gives money to the borrower on certain terms and conditions. These terms and conditions include the interest clause that, okay, I'm giving you so and so money for so and so duration on so and so interest rate. Okay, and you are liable to pay me this amount, this principal amount along with the interest starting from this particular date, and you have to comply with all the conditions set forth in the loan agreement. And if in case the borrower fails to comply with the conditions set forth therein and fails to repay the loan within the timeline as stipulated in the agreement, then in that case, the lender will be entitled to take hold of the collateral which has been given as security. Okay. Now, what is the difference between a facility agreement and a loan agreement? A loan agreement is a contract which only be entered into if the lender has effectively transferred the funds to the borrower. Now, here the word to catch is effectively transfer the funds to the borrower. However, in a facility agreement is intended by the parties wherein the lender only promises to lend. Here, the particular word is promises to lend a loan to the borrower. Now, one loan agreement is entered when already a transfer has taken place, but a facility agreement is entered when there is an intention to deliver the money or transfer the money in future upon the request of the borrower. Okay, now there are two types of loans. One is secured loans and one is unsecured loans. Now everyone must know what is secured and what is unsecured loan. I want an answer from you apart from Ajaz. What do you understand by secured and unsecured loans?
Ma'am, a secured loan is something where you keep something as an security.
Okay. Can you give me an example?
For example, if you're taking a loan from some gold finance company, you're pledging your gold
Mm-hmm.
as a security,
Mm-hmm.
and then you take a loan from the finance company for interest.
Right. And on the other hand, the unsecured loan is
Something
where you do
which you
not
don't.
require anything as a collateral for taking the loan or the money from the bank. Okay.
Yes, ma'am.
So, unsecured loan is advanced to a borrower, commonly in small business owners on an unsecured basis. The perfect example of this is bank credit cards and personal loans. On the other hand, secured loans cover automobile loan or real estate loan on which we are mortgaging or pledging something as a security. Now, coming on to the drafting part. So this first line is the introductory clause. This loan agreement hereinafter defined as the agreement is entered on so and so date, which is termed as effective date. Here you can also add at so and so place if there is a place. Okay. By a company or a bank incorporated under so and so laws, having its registered office at so and so place, hereinafter referred to as lender. On the other hand, an individual having its Aadhaar or PAN number as so and so, permanent address at so and so, hereinafter referred to as borrower. Either it can be an individual or it can be a company. So over here, I have defined the terms or I have drafted the terms as per company so that you get Just give me a second. Yes. So here in this agreement, I have drafted the clauses according to a company. But for your understanding, I have included both the things over here. Either it can be an individual who is taking the loan, or it can be a company who is taking the loan. Okay. Now comes the recital clause. The borrower is in the business of construction and development of real estate, commercial and residential. Okay. The borrower wishes to construct a housing society to be situated at so and so place, which is the purpose of the loan, and is desirous of availing so and so amount from the lender. Pursuant to the mutual discussions, the lender has agreed to grant to the borrower the loan of rupees so and so towards the purpose of this agreement, and the borrower agrees to use the loan on the terms and conditions set forth herein. Okay. So now here the borrower is a company who is into the real estate business and wants to construct a housing property or housing society at a particular place. And for the development of that particular housing society, it requires a loan from this bank of so and so rupees. And now they have mutually agreed that okay, the terms and conditions as set forth herein will govern this particular arrangement between them. Now comes the definitions clause. Now this definitions clause, let me go through it first. The capitalized terms are defined words and the meanings are set out in this agreement. The words which are used in this agreement, which have special meanings, specially defined words and other guides to understanding this agreement can be found at the end of this agreement in Schedule A, as set out in this agreement, if not earlier defined in the body of the agreement. So what does this clause says? That all the terms which are defined, like I have defined the term agreement over here in, lender over here in, borrower and company. Okay. So these terms which are defined in this agreement are highlighted and bold in semicolons. Okay. And if not defined while in the drafting of the clauses, then they are separately put at the end of this agreement in Schedule A. Okay. So this basically tells you that what all terms are there which are repeatedly being used and are defined. This agreement and documents referred to in it represents the entire agreement between the parties in relation to the loan and supersedes all the previous agreements and understanding, whether written or oral, relating to the subject matter hereof. This agreement supersedes any offer, agreement, or term sheet issued in connection with the loan made available hereunder, and such offer, agreement, or term sheet shall have no legal effect. Now tell me, what do you understand by the term sheet? Anyone is aware of this term sheet?
No, ma'am.
Okay.
Term sheet, ma'am, where the duration and the what we say. Term sheet. Sorry, I forgot it now.
It's okay. Just give me a second. I'll share one term sheet which I made so that you guys can have a look at that and get an idea of what a term sheet is. Just give me a second. So if you guys remember, we discussed about the hotel asset management agreement, right?
Yes, ma'am.
Yes. So this is the term sheet of hotel asset management agreement. If you see all the clauses over here in this portion are similar to what we have drafted over there. Okay. So term sheet is nothing but just a summary form of what we will be entering into. This is basically a short document which we share with the other party to showcase them or to discuss with them that, okay, these are the terms which we will be entering into, and this is the idea of entering into. If you want to include something, if you want to negotiate on something, you can just let us know. So that this is basically a summary draft of what we will be entering into. This is known as the term sheet. It's in the form of a table. So if you will see over here, the services, what all services will be provided by the manager: volume ramp up, high demand, performance stabilization, turning point, all these things. And what will be the capabilities? These are the capabilities. What will be the term? The term will be 10 years. What are the expenses? These are the expenses. How will they be paid? What will be the fee structure? This is the fee structure. So everything which we have actually drafted in that particular agreement is already discussed over here in a term sheet in a very brief manner. Okay, so this brief or the summary of that particular agreement is shared with the other party, and if that other party agrees to all these terms of the term sheet, then we actually go into the drafting of the agreement. Understood?
Yes, ma'am. Got it.
Yes. Okay. Screen is not visible.
Now visible, ma'am.
Okay. So that this particular clause says that now this agreement which we are entering into, which is known as the loan agreement, supersedes all the previous agreements or the term sheets which we have mutually exchanged between us. Okay, suppose there is one term sheet which I have exchanged with the lender, and now the lender wants to incorporate certain things. He made certain changes, and then we have a second term sheet, then we have a third term sheet, or any mutual email exchanges. Now this agreement, this particular agreement, will supersede all those email communications, all those communications, prior arrangement, or the term sheets which were exchanged between the parties, and this is the final and binding upon the parties. Okay, each of the party acknowledges and agrees that in entering into this agreement, it does not rely upon and shall have no remedy in respect of any statement, representation, warranty, understanding, promise, or assurance of any person other than expressly set out in this agreement. So what this clause is saying is that whatever has been set out in this particular agreement explicitly, the parties will be bound by only those things, and no other remedy will be provided to any third party if not included under this agreement explicitly. Then comes the interpretation clause. This is a very simple boilerplate clause. You can just go through it once I share the agreement. There's nothing to discuss over here. Then comes the conditions and purpose. Subject to the lender having received, now before we proceed further, just comment in the the text box what all terms should be there in a particular loan agreement. What according to you are the essential terms that should be included in a loan agreement? I have already told you while I was explaining what is the meaning of the loan agreement. Quickly, guys. Just one term from one student. Loan amount, okay. Rate of interest, okay. What else? repayment dates, repayment details. Okay, good. Only Paras is answering. Okay, fine. Security. Yes, if we are entering into the secured loan. Also, just let me know whether this particular, we have already gone through the recital clause. So now let me know that what according to you, will this be a secured loan or will this be an unsecured loan? Apart from Paras, unmute yourself and just tell me what according to you will be this loan agreement be. Either it will be a loan, a secured loan, or a non-secured, unsecured loan. Yes, guys, speak up. Bhavya, सब ज्वाइन करके भाग गए क्या?
No, ma'am.
Okay. Chalo. This will be a secured loan agreement for the reason because if you have seen the recital clause, it talks about we are taking a loan for the development of a housing society and it is the real estate business which is being run by the company, which is the borrower over here. Okay. So now this is, of course, a loan amount in this agreement will be a heavy amount. Okay, and when there is a heavy amount and the term of loan is also of a longer duration, then it's always preferred to have a secured loan agreement. And in this case also we will be having a secured loan agreement. Okay, let's move on to the next clause. Subject to the lender having received and found satisfactory, the borrower shall provide relevant documents and comply with the conditions prior to drawing the loan. A copy of resolution. So what is this particular clause talking about? That prior to entering into this agreement, borrower will provide all the documents which are required in order to comply with the conditions of this loan. Secondly, it will provide a copy of resolution because this is a company. There will be a board resolution. There will be a certified copy of the authorized signatory, who is the authorized signatory. And of course, a company will take this loan through an authorized representative. So that particular authorization has to be on board with the lender. All this needs to be there handed over properly to the lender before entering into this agreement. This is what are the two conditions set forth herein. This clause signifies the requirement of a copy of resolution of the directors certified by the authorized signatory of the borrower to be in full force and effect at the date of receipt by the lender. This is required when the borrower is a company which needs to procure a loan. A copy of resolution is required to affirm collective assent, which is confirmed by the directors of the borrower. So basically, this will affirm that yes, if a particular, suppose XYZ person is taking a loan in the name of the company, then that particular resolution will make it assure that yes, this loan is being taken for the benefit of the company and all the other directors have given their assent to this. Okay. Then what is the second conditions? A guarantee from the guarantor and consent of to the effect of the guarantee. Now, because this is a secured loan, so here a guarantee will be taken from the guarantor, whoever will act as a guarantor on behalf of the company. So a guarantee and a consent from him that yes, he has no objections to this grant of loan, and if in case a company defaults, then that this particular person will act as a guarantor and will repay the loan to the lender. A copy of MOA and AOA of the borrower certified by the authorized signatory. a security documents duly executed by the company. So whatever, suppose we are taking a loan of 10 crores from the particular lender, and in security we are giving the documents of a particular property which is already there in Delhi, which is of the value of 12 crores. Okay. So these documents of that particular property of the company, which is of a value of more than the principal amount which we are taking from the particular bank or the lender, are known as the security documents, and that those documents will be duly executed by the company and will be handed over to the lender as a security. According to this clause, the lender shall advance the loan amount in full, and the borrower has a right to draw from the loan amount as per its requirement. This withdrawal can be recurring in nature. So if you see this clause, the borrower shall be entitled to draw and lender shall advance the loan in full. So now what does this clause mean? Suppose XYZ company is taking a loan of rupees 10 crores for development of a housing society in Gurugram. Okay. So now lender will pay this loan amount to the XYZ company on the date of entering into this agreement in full. Okay. So now what the lender has done, lender has given this entire amount of rupees 10 crores to the company in advance in full. Okay, but now it is the discretion of XYZ company to use this amount or to draw this amount from their account in installments. Okay, suppose this loan effective date of this loan agreement is 16/6/2024. Okay, so now XYZ can use a part, suppose 5 crores of this loan amount on 30th of June. Then they can again draw a part which is like 66 crores, or the remaining 3 crores on December 2024, and then remaining so and so. So now lender has paid this entire agreement, entire loan amount to the company in one go in full, but it is the borrower who is entitled to draw this loan amount in part. Okay, any doubt in this clause? Okay, moving forward. The lender will, in consideration of the borrower agreeing to repay the loan on the terms of this agreement, advance up to the amount of rupees itna in full to the borrower in respect of the borrower's specified or agreed purpose. The loan shall not be used for any other purpose by the borrower without the prior consent of the lender. So now what is this clause saying? That the monies which has been advanced as a loan amount to the borrower can be used only for the purpose which is enumerated herein in this agreement. For example, if here in this agreement we have taken the loan for the purpose of development of a housing society. So if the borrower tries to use this money for any other purpose apart from what has been agreed, then the lender will be entitled to immediately terminate this agreement, and he can also block the payments. He can also ask the borrower to immediately repay whatever he has used from the account which was not agreed. Okay, or he can even charge penalties and issue the notice of compliance to the borrower. Any doubt in this clause? Screen is not visible.
Yes, ma'am, it's visible.
Okay. Any doubt, class? These loan
Ma'am,
agreements are a
can you
bit
repeat the
tricky.
comment part?
Okay, give me a second. This is a key clause with respect to the application of monies advanced through the loan to the borrower. The borrower can only
Ma'am,
use this.
what is the meaning of monies here?
Monies is equivalent to money.
Okay, ma'am.
Yes. The money, the borrower can use this loan with respect to the purpose for which it was initially subscribed for. For example, if the borrower is availing a loan for the construction of new headquarters, so this is an example. Here we have agreed that the borrower is availing loan for the construction of housing society. Then the company is mandated, this is the keyword, mandated to use the loan amount only with respect to the construction of the housing society and for such services in connection with the construction of the housing society. However, if the borrower chooses to use this loan money for alternative use, then the lender might either block the loan amount for the further withdrawals and can demand the repayment of the drawn loan either immediately or may give him certain days after default, or may even charge penalties and issue a notice of compliance. Now, is it clear?
Yes, ma'am. Now clear.
Yes. Now coming on to the next clause, which is the repayment of in debt. The borrower shall repay the loan together with all the debt without deduction or set off or on the first to the occur of the following. First, in the event of default, then the repayment date, which is the 30th day following a written demand by the lender to the borrower requesting the repayment of loan. So this clause is subject to variation depending upon the discretion of the contracting parties. Now there can be an ample of ways of repayment. Either this can start from a particular date, or it can occur on the particular event of default, or there can be a certain term that, okay, I am giving you this loan agreement for the period of 10 years, and after 10 years, you will be liable to pay the interest and so on. So this is very subjective depending upon what the parties are desirous to enter into. If the repayment of the loan or indebtedness falls on the date which is not a business day, the due date for such payment will be extended to the next business days. This is a simple clause, nothing to explain. The loan and any indebtedness shall be paid without deduction or set off in currency to such account or accounts as may be specified. So this loan will be paid without any deduction. So there will be no deductions, whether it is of tax or anything. Whatever the lender has paid, the borrower is liable to repay the same along with the interest. The borrower may repay or prepay the loan or indebtedness or any part of it early, but may not reborrow any amount so repaid. What does this clause means? This clause specifies that the repayment or prepayment of a loan amount in the form of either it can be monthly, quarterly, half yearly, yearly installments is not subject to reborrowing of the said amount. In addition to the repayment guidelines mentioned in this agreement, a subsequent subclause regarding the cleanup could be added. What is the cleanup clause? A cleanup clause is a contractual provision which specifies that a borrower, upon the repayment of loan upon a stipulated period of time, would not be entitled to made available for other loan for the period of so and so days. So now what is this clause saying? Basically, this means that suppose XYZ company has taken a loan of rupees 10 crores for a period of 10 years, okay? And the repayment is starting from so and so date, okay? Now, if a particular party, XYZ company, prepays, suppose it prepays 5 crores before the date of repayment, then in that case, XYZ cannot come later and ask to re-borrow this loan amount prepaid. Getting it? Any doubt in this clause? Any doubt, class? Anyone?
Yes, ma'am. Clause 3.4. I didn't
Yes?
Ma'am, 3.4 clause. Repayment of loan. Like, ma'am, you give the example XYZ. Well, I didn't understand.
Yes, okay. I'll explain it again. So what is this saying? कि suppose XYZ company ने कुछ loan लिया है, ठीक है, from the particular person or the lender, ठीक है, and now XYZ company is prepaying. Of course, if you have taken a loan, you have to repay that to a lender, okay? And before that particular date of repayment, suppose that date of repayment is in December, you have decided, you have the monies now, and you have decided, okay, I will not wait till December, I am willing to pay this particular amount in the month of August only. So if you are prepaying this amount in the month of August, this part payment, if you are paying this in the month of August, then you cannot come to the lender again and ask him to re-borrow you. Suppose you in October again wants to borrow some money, and you are again coming to the same lender and asking him that, okay sir, my repayment date was in December, and because I have prepaid you certain amount in the month of August, I want to re-borrow this amount from you and I will repay to you in the month of December only. So you cannot do this. Okay,
Yes,
I
ma'am.
hope it's clear
Yes,
now.
ma'am. Yes, ma'am. Got it.
Yes. Now coming on to the interest and default interest. The principal amount of loan outstanding shall carry an interest at the rate of so and so percent per annum above the base rate as varied from time to time of the lender, accruing daily and payable in arrears upon the repayment of loan. So this clause is saying that so and so will be the interest charge on the principal amount, which is of 10 crores, and this will be on a daily basis and will be charged per annum and will be paid at the time of repayment of loan. Okay, interest at the rate of so and so per annum above the base rate of the lender from time to time shall accrue for the from the repayment date on the loan, to the extent that loan has not been repaid pursuant to this, compound monthly on the last date of each month and calculated both before and after the demand or judgment on a daily basis and a year. So what is this clause actually saying is, whatever you have paid, suppose you have taken a loan of rupees 10 crores and you have paid 5 crores on a certain date, then whatever is remaining, the interest will be charged on that remaining amount. Okay. Then comes prepayment and security. What do you understand by the term prepayment? Yes.
Ma'am, it is up to the lender to decide is compound interest or simple interest.
Yes, it is up to the lender who has to decide that what will be the interest rate, whether it will be a compound interest, whether it will be a simple interest. Okay. What do you understand by the term prepayment? Anyone?
Paid the loan amount before it's actually scheduled.
Yes, right. Before the repayment date, paying a loan amount, repaying a loan amount, actually repaying a loan amount before the particular date of repayment. The borrower may prepay the whole or a part of loan at any time. This clause is subject to another variation, being that the lender can restrict the borrower from any prepayment, and upon non-compliance of the same, a prepayment penalty can be charged by a lender. This practice is adopted because it is construed that all the interest, which is the difference between the principal amount and the amount received upon the repayment of the loan, which is the remuneration for the lender, shall be payable to the lender. Thus, prepayment of a loan amount is discouraged by the lender. What do you understand by this comment? First, you try to explain me, and then I'll explain you what does this mean. Yes. What do you guys understand by this particular comment? No one? Okay. So what is this saying? That you can definitely have a prepayment clause in your agreements. But what lenders, if you see from the perspective of a lender who is giving you a loan amount for so and so duration, what is the remuneration for the banks? Why are banks giving you loan amount for such a long duration? Because they are getting the benefit from the interest which they are charging you, right?
Yes, ma'am.
And if you will prepay the loan before that particular date, then what will be the source of remuneration for the lender? So this comment is saying that in certain cases there are few lenders who restrict this prepayment clause, and even just to ensure that you do not prepay the loan before a particular date, they can even impose a prepayment penalty upon the borrower. This is what this comment is saying. Understood?
Yes, ma'am.
Okay. The repayment of loan and indebtedness will be secured by way of fixed or floating charge over the assets of the borrower as specified in the security documents. So this is now talking about what will be the charge. So this can be either fixed or floating charge depending upon the security documents which we have submitted. The borrower shall at its cost and expense ensure that all the documents, registrations, consents, licenses, and other matters and things reasonably required by the lender in connection with the security afforded to the lender are promptly produced, executed, obtained, filed, or made. So this clause is favorable to the lender just in order to ensure that all the documents which a borrower is providing to the lender in exchange of the security are duly verified and executed. Okay. The repayment of the loan or indebtedness shall be secured by a guarantee from the guarantor. So besides the security, there is also a guarantor over herein who is taking the guarantee of this loan. The loan together with interest, compound interest, cost, charges, and monies whatsoever stipulated in this agreement shall be secured by an exclusive mortgage of a residential property. So now here I have included that what are we actually putting in as a security. Here we are giving, give me a second. So here we are exchanging the residential property, and we are mortgaging the residential property in exchange of this loan agreement. Now, there are certain representations and warranties, which includes the legal status. Borrower will represent and warrant that it has a proper legal status. It is duly incorporated as per the laws and provisions of the Indian laws. Okay. It has proper assets. It has all the approvals. It has all the obligations and it is bound by all the obligations of this agreement. It has all the powers. It shall not act in any conflict of any of the laws, regulations, or any other agreement which they have entered into. It shall not default in the payment. It shall maintain the security interest and shall not mortgage, charge, pledge, or lien that particular security to any other third party under any other agreement. It is not involved in any litigation, or none of the litigations or the court orders are there which may adversely affect their business or this particular loan agreement or may affect the security which they are exchanging. They have proper authorizations to enter into this agreement. They have a borrowing limit which have been fully complied with. They have all the informations related to the lender and have already disclosed all the information which the lender should have been aware of about the borrower. They have properly stamped and everything. They are not in breach of any of the rules, regulations, and they are under compliance with all the proper licenses, authorizations, and permits. Any doubt in this representation and warranties? Any doubt, class?
No, ma'am.
Okay. Now moving on to the next clause, which is the undertaking. So undertaking and representations and warranties are more or less same. You can just go through this clause and let me know if you have any doubt. Just go through this clause quickly. Any doubt? Should I move on to the next clause? Okay, I'm moving on to the next clause. Next clause talks about the insurance obligations. The borrower shall insure and keep insured all the assets against such risks as the lender may require for the specified value, their full reinstatement and replacement value with insurance company and such insurance under such policies and lender may approve, including but without prejudice to the generality of the foregoing insurance against loss or damage howsoever caused or arising any third party insurance. So this clause is related to the security. Now the borrower shall ensure that all the assets of the company and the security document and the security which the borrower is keeping in exchange of the loan amount is properly insured and its value is completely reinstated from time to time. Then what are the events of default? The lender shall be entitled at any time after the occurrence of event of default by notice in writing to the borrower to declare that the indebtedness had become immediately due and payable and the borrower shall immediately pay the same to the lender. Now, in case of event of default, as we have discussed earlier as well, in clause, which was the clause? Yes, for the purpose clause. I told you about the purpose clause, that in case this money is used for any other purposes apart from what has been enumerated in the purpose clause, that will amount to an event of default. And if such default occurs, then the lender shall be entitled to an immediate repayment of that particular amount. Now, an event of default occurs if the borrower suffers a change of control without the prior consent of the lender, or is subject to any trade sale, flotation, or refinancing. And change in control means any event in which either more than 51% of the voting power of the borrower vests with the company other than the subsidiary of the borrower by equity purchase, contract, or otherwise. A company other than a subsidiary of the borrower acquires the right to direct more than 51% of the voting rights in the borrower. So apart from that event of default, which I have discussed, that apart from using this particular loan amount for any other purpose which is not discussed or agreed here in this contract, if there is a change in the voting right, or there is a change in control of the company, which has to be more than 51%, if there is so and so change without the intimation or to the lender, then that will also amount to an event of default. If the borrower issues, allots, buybacks, or redeems any shares in its capitals, makes any changes in the memorandum or article, or alters any rights attaching to the issued share without the prior. So basically, this clause is saying that whatsoever major changes are happening in the company, which is the borrower, if any of the changes occurs without the intimation, due intimation to the lender, that will amount to an event of default. And these are the scenarios under which the particular change in the company will amount to the event of default. In the event that the loan shall be declared immediately due, in the event that the loan shall be declared immediately due and payable as stated above, the borrower will reimburse the lender for all the losses and expenses incurred by the lender as a consequence of event of default. The certificate of the lender as to the amount of such losses and expenses shall be in absence of manifest error and be conclusive. Okay. So now here it is saying that whatever changes has happened in the control of the borrower company, if those amounts to an event of default, then all the losses or all the expenses which the lender has incurred due to this change in event or this event of default, all these will be reimbursed by the borrower. Then comes the fees and expenses. This is a simple clause which is saying that all the fees and expenses for the execution of this particular agreement and the execution of the security documents or any other documents will be incurred by the borrower. Then currency and payments. This clause says that the payment shall be made in the currency of the country in which this agreement is entered into. Suppose this agreement is being entered into India, then it will be in rupees. The currency exchange will be in rupees. If suppose it is entering, if this agreement is being entered into US, then the currency exchange will be in dollars and so on. Okay, so this is a simple clause saying that particular thing. Then comes the notices. What will be the address and
Ma'am,
how the
clause 11.3.
11.3.
Yes.
All sums payable by the borrower under this agreement shall be paid in full without any set-off or counterclaim, and save in so far as required by law to the contrary, free and clear of and without any deduction or withholding from any payment to the lender. Then the borrower will immediately pay to the lender any such additional amounts and will result in the lender receiving the full amount it would have received had no such deduction or withholding been required and will simultaneously provide the lender with a certificate of deduction or withholding in respect of the amount deducted or withheld, together with evidence satisfactory to the lender that the amount so deducted or withheld has been paid over to the relevant authorities. Now, this clause is saying, suppose XYZ company is deducting, suppose rupees 50 lakhs from the repayment amount. Then if this XYZ is deducting this 50 lakhs from the repayment amount, then it has to provide a proper documentation showing that why it has deducted this 50 lakhs amount from the repayment amount, and showing the proof that this 50 lakhs has been deducted for so and so reasons and has been paid to so and so authority, which the lender was liable to pay, and on the part of lender the borrower has already paid that amount to so and so company or to the so and so authority. Okay, you still have a doubt?
Means, ma'am, borrower have paid the amount to the any authority on behalf of lender.
Yes, right. This clause is saying that first the borrower is not entitled, or the borrower has to pay the exact amount which the borrower is liable to pay, which will include the principal amount as well as the interest. And if in case the borrower is not paying that particular amount, or is deducting certain amount, or is setting off certain amount, then why it is doing so and to which authority is he or she paying that amount to has to be disclosed with proper documentation to the lender. Okay.
Yes, ma'am.
Yes. Then there comes the clause of notices. This is a simple clause which is saying that the borrower will send the notices to the lender on its so and so address, and similarly the lender will deliver the notices or communications under this agreement required on so and so parties to so and so address and in this manner. Okay, it can be sent either by fax or by email, or it can be sent to the address. Okay, then comes the assignment. This assignment clause says the borrower here cannot assign or transfer or mortgage or do anything related to this agreement. He cannot assign, transfer, or do anything related to this agreement to the third party without the prior consent of the lender. But a lender may assign or transfer any of the right or obligations either in whole or in part under this agreement with prior consent of the borrower. This clause is saying that the person who is borrowing the money is bound to follow the instructions, is bound to perform the obligations set forth herein in this agreement, and he cannot transfer or further assign all his duties and obligations under this agreement to any third party. But a lender can do so, but this has to be done with the prior consent of the borrower. Okay. Then these are certain boilerplate clauses which we include in all the agreements. You can just go through these boilerplate clauses, and if there is any doubt, we can discuss the same in the evening class.
Ma'am,
Any doubt?
Ayad has raised his hand. Ayad, you can ask.
Yeah, can we put the waive-off clause like in the certain situation or unforeseeable situation where the interest or penalty will be the waive-off in the loan agreement? Suppose in the like in the corona, so many people who cannot do their business and pay the loans and all this thing on time. At certain situation, we can able to put the waive-off clauses.
Yes, there can be force majeure clause. In
Yes, ma'am.
all the agreements, we can have this force majeure clause. I have already discussed what is force majeure clause in one of the agreements which we were discussing. So that clause can come into this agreement as well. You can have this clause over here as 14.15, which is a force majeure clause. Which will say that on the happening of so and so, which may include floods, pandemic, earthquake, or say war, anything like that, on so and so, on the happening of so and so events, the lender agrees that the interest amount during that particular period shall be, or it's better to have a may clause, may be waived off depending upon the severity of those events. Okay, you can have a clause like this. Okay, just
Yes, ma'am. Ma'am, one more
yes.
thing that if we are saying that lender can pay the loan amount at any time, and then we are saying to that those who are borrower of this amount, they can restrict to pay the loan amount or the prepayment amount. It will be not contradict.
No, no, I was just explaining. If you will see, I have included that particular clause in the comment section. So that was in order to explain you that yes, we do have prepayment clauses, but there are certain lenders who do not prefer this payment prepayment clause and can restrict the borrowers from the prepayment, and to in order to ensure that they do not prepay the loan, they can even impose a prepayment penalty upon them.
But laws are allowed to grant the pre penalties for the
Yes,
prepayment because
yes, of
maybe it is
course.
okay.
It's because this
Even they are paying the interest amount for this certain duration which he took the loan.
so see, here I have not termed that this particular lender is a bank or a government bank or a private bank. So definitely there are different laws, rules and regulations of banks, private banks, NBFCs. Here this lender is a company. Okay. If you will see, this lender is a company. So it can be any company. It can be your company lending a loan to my company. So
Okay,
then in that case, definitely they can agree upon any of the term they want to.
okay,
Yes. If in case it was a bank, then definitely they have to make sure that they do not contradict with any of the rules, regulations set forth by the RBI or by the NBFC, and they
correct,
have to comply with those rules and regulations. And in case there is any conflict between the terms and conditions of the agreement and the rules and regulations, then in such case the rules and regulations will supersede the loan agreement.
correct. But even in this case, even in if the company is there, then there should be a in under the purview of the laws only.
It has to be in the purview of law, but there is no such law which restricts you to put a penalty upon the prepayment.
Okay, okay,
Yes.
got it. Thank you.
So this was about the loan agreement. In the next class, which we are having at 4, I will first discuss about the intercreditor agreement. And then if you have any doubt regarding any of the agreements which we have discussed till date, because that will be our last class, so you can put up your doubts. Okay. Okay. So let's end this class for now, and we'll meet up in the evening at 4.
Oh, okay, ma'am. Thank you so much, ma'am, for
Okay.
attending the class on loan agreement.
Thank
Uh,
you.
all the doubts are cleared in the evening session.
Yes, please. Whatever doubts you have, you can just